Hi, everybody. Welcome to another episode of Tax Sale Insiders. I'm your host. I'm Brian Seidensticker. I'm the CEO of Tax Sale Resources. With me today is, an old friend. We've been blessed by your presence a few times, Stephen Morel, and Stephen's with the Jurisdeed. He's also an attorney, based out of Louisiana, and wanted to revisit a couple things, Stephen. But welcome.
Yeah, thanks for having me once again. It's always fun to be here. Always fun to be chatting with you about the latest and greatest in tax sales and the never-ending journey in Louisiana and how we're dealing with it in our state.
Yeah, and I think I've said recently, rarely do I say with full honesty that it's exciting times in the tax industry, but I think it truly is exciting times in the tax industry. Whether that's exciting good or exciting bad, I guess, is in the eye of the beholder. But
right,
last time we spoke, you're on a committee, right, in Louisiana, really with the mission of revisiting or rewriting the statutes that govern the tax sale process in Louisiana to be a little more understandable, a little more, I guess, friendly for all parties involved, right? And maybe we'll start with just kind of revisiting what the direction that you were going as a committee, and hopefully that the legislative session was going to adopt. And then I do want to dive into really why we're here today, is kind of talk about what about the Hennepin Supreme Court case that maybe changed some of that. So let's start with just give us a quick overview of the proposed changes pre Hennepin that the committee was going down and changing Louisiana.
Yeah, the biggest things is the bid down of ownership percentage, which is obviously the only, I believe, one of only two states in the country that even have something of that nature. But this was maybe the other state is like a backup method to break ties in bidding or something. But this is Louisiana's primary method of the biddable component at the tax lien auction is to bid down the percentage of ownership in the underlying collateral property that the lien investor would take in the event it doesn't redeem. Similar to if you were to co-own property with your sibling, you wouldn't own 100% of this one thing. You would own a percentage of that one thing. And so that's how we would, it's a way it's been for over 100 years. It's problematic, as you can imagine. That just creates a title mess if you have partial ownership interest floating out there. And we've had serious issues with our assessors not knowing what to do with that and creating separate tax bills and thinking that it was a separate parcel of land. And really, it's the same piece of dirt. It's just a new tax bill now. And then that tax bill, 1% of something goes to tax sale. And it's just a spiraling mess.
Right.
So there's been a concerted effort to do that, to get that changed. As you may have heard, Louisiana made a comprehensive overhaul of its statutes back in 2009, which is performing really, really well. But that was all statutory, and this bid down of ownership is in the Constitution. So they left that alone because of the burden of trying to push that out and make it or change it, and we're able to effectuate some pretty significant advances through the statutes. But it has to all be updated. And there's just a bunch of other things that were problematic in the way that we were enforcing for unredeemed tax liens to try to convert them into deeds, et cetera. And really, the main goal was to maintain a fair system, but that also left these tax titles with good title. At the end of the day, it doesn't do anyone any good for these to be circulating out of commerce because no one can get clear insurable title. So from a legal and title perspective, we wanted to make sure that what came out the other end was something that was sustainable and merchantable. So I feel like that we're on a really good path to still do that in light of Tyler, although it's certainly going to make us adjust a few things so that we're staying in compliant with the new decision.
Got it. So the really the main change that the committee was going down is just, I guess, removing the ownership bid method and replacing it with what? I think it was a bid down percentage.
I left that part out. So replacing it with a bid up premium, we were still undecided as to what then, with the overbid. Obviously now this is something to be taken into serious consideration, with what the overbid being, potentially part of this, if depending on how you look at the Tyler decision, if that's relevant to how you should handle it. But yeah, a bid up premium for sure. Starting bid being the total delinquent tax sum, that's owed at the time of the sale, and who's the highest bidder at that point.
And just to clarify, we're talking about the lien, because I know there's lien sales, right? And then there's the deed. I'll call them the deed sales, right? And the changes were really more geared toward the lien sale only, not really touching the deed sale process. Well, is that accurate?
That's right. And so just to keep if everyone listening to this is not, a practitioner of Louisiana tax sale law, you may not know this, or if you've already been investing in Louisiana for a while, it's not a dual system like Florida where there's two sales of the same investment. There's not a lien sale that then there's a subsequent foreclosure in a sheriff sale of that lien. The deed sale that obviously you're referring to are the ones that didn't sell at the tax lien sale, and the county or our parishes end up taking them, not ownership, but take the custodian duties back, and then they have to one day get that thing back into commerce, and there's a statutory procedure to allow them to auction off the property if they've been holding it unredeemed for 3+ years. Then they can actually go down and try to sell the real estate or donate it, et cetera. But those are the deed sales that are the only ones. Right. So there's the conversion process in Louisiana, as it stands today, is the unredeemed tax lien holder has the exclusive right to then go and convert that to a deed through one of a couple of methods. One's judicial, one's non-judicial, and that's what's the current law.
Got it. Okay. So the committee was going down the path to change the bidding method on the lien sales from a bid down ownership percentage to a premium bid method, which is pretty standard in many states. And then I think it was end of May, the Supreme Court decided to hear this Tyler versus Hennepin, which is based in Minnesota, and came out with I don't know if a ruling is the right word. I guess I'm not an attorney, Stephen, so you can correct me here, but at least a decision, right? A decision and an opinion from their end, right? That basically said, well, what Tyler, basically what Hennepin County had done was unconstitutional, right? And then there's a whole lot of other description in that decision that has created a lot of I call excitement, right? But a lot of discussion in the industry of what does this mean, right? You guys were going down the committee, right? And Louisiana was going down the road of changing the statutes already,
yeah.
And I think you'd mentioned earlier, I think maybe before we started recording, but luckily it was something you guys were already doing and could meet and say, okay, what other changes could we make to make sure that we're adhering to this decision, right? But maybe let's start with, I guess, what components of the Tyler Hennepin case did you as a committee look at and say, okay, these are the main things we need to make sure that we are adhering to?
The biggest takeaway, just to keep everything in context, from the Tyler case, and I don't think this is really the debatable portion, if there is one, is it focused on the takings clause of the U.S. Constitution rather than what most, if not all, other prior U.S. Supreme Court decisions had focused on, was the due process clause. Either way, it's a constitutional protection, in violation of which makes the system unusable or void. But it was unique in the sense that it focused on the takings clause, and the takings clause is a protection against an uncompensated taking of the government without delivering back adequate value for what they've taken. You think of that in the context of like an expropriation, right? Where I've got to build this interstate through here, but here's a fair amount of money to give you in return for taking that property from you. And in the Tyler case, that there was as there typically is, if it's an unredeemed tax sale, then the property gets forfeited at some kind of foreclosure proceeding. But the reason for that whole proceeding to be there was because of unpaid taxes, right? And that was the debt that was owed, but the property sold for much more, and that equity was, they correctly ruled was that in favor of the plaintiff against the county, that equity belonged to the homeowner, and that was, it was in excess of the debt. And now they didn't get into like whether there could have been subordinate lien holders and that kind of thing. I think that would have been a fair evaluation had there been some. But if you take something more than what you're owed away from that person, it's that there's the takings, right? So it's uncompensated. Right. It's not fair. And in Louisiana, we had a system of bidding down this ownership percentage. But that's still a percentage of something that equals something, right? So it doesn't matter that it's a percentage, because at the end of the day, it's like, well, what does that equal? What is the value of that? And so if a Louisiana tax lien holder goes and converts this to a deed and has a partial ownership interest, and just as an aside, that the process of liquidating that partial ownership interest is the same you would do if you wanted to partition a property in any state, and for any reason, you and your siblings disagree on what to do with the property, but you all have to agree if you're going to do something with it, right? So then you have to say, well, we don't agree. All right, we'll go to court and just have them put it up on the auction block, sell the property, and everyone gets their piece. Everyone gets their check, right? You liquidate the property. It's an immovable object. You can't chop it up. Right. Similar to that, the tax sale lien holder does the same thing and goes and enforces this partition sale after quieting title to their partial ownership interest to liquidate their portion.
Sorry to cut you out. I just want before we go too far down that, because I want to get into the fun stuff. I think there's a common misconception for investors that maybe have heard of the Tyler Hennepin case. The ruling didn't say that tax sales were unconstitutional, right? And I've heard that from a few customers that have called in, and that's not what they decided. What they decided, like you said, it focused on the taking clause. Not that the tax sale was unconstitutional. It was the compensation to the previous owner of that property basically hadn't received everything, and that's what they said is unconstitutional. Like, okay, if the government is going to essentially confiscate this property for a debt, right, they should be compensated for anything above that. That was the ruling, right? So, so I just want to make clear for anybody that's listening.
Let me jump on that. I'm sorry. Let me add one more thing on that, because I think it's also very, very important qualification to your listeners and to anyone who's trying to figure out, like, okay, what now? Like the Supreme Court is supposed to, and in this case did, set very high level rulings on major issues that are undecided, right, or where there's conflicts between the appellate circuits, et cetera. They don't necessarily get into the weeds on particular fact scenarios that might, especially when they're different from what was presented in the underlying case. And in here, it's based on the takings clause. Like, that was what fueled the ultimate decision. But what they're not saying is that if there's excess equity from a sale, that it's automatically a constitutional violation. But it's not an automatic application of unconstitutionality just because a surplus was created. The unconstitutional portion was because one was created and that county had no procedure to allow the homeowner to come back and get it.
Right.
There's your constitutional violation, right? It now, having a surplus certainly put things on the sidelines of unconstitutionality and saying, hey, this could be bad for you, but in other jurisdictions or the states that have a process and say, okay, we have a surplus now. All right, now let's go find the homeowner. Let's send them notification. Let's say, hey, you have a right to come get this. You have X amount of time to get it. The Supreme Court didn't say, sorry, we can't move forward. Everything, the wheels of justice are going to stop now because a surplus was created. Right. It's that you have to do it correctly now that a surplus is created. And I think that's a really key distinction, and one that many people I've heard, even lawyers, et cetera, who just take this and run with it, saying, oh, yeah, if you have a surplus, we're done. Like, we gotta stop having surplus. So, like, Stop having surpluses. That's not the answer. That's not what they're trying to say. They're saying don't have an unfair, an unconstitutional system of withholding that surplus from the homeowner to whom it's entitled, right?
Right.
And it's not unfair. Just like if you look at the due process clause, you can move forward if they don't show up in court, if you gave them adequate notice and time to show up in court, right? And they said, oh, you could have it. I'm not showing up in court. That doesn't stop the lawsuit. If they were properly served, they chose not to show up, or if you did a reasonable effort, it's that, which you've heard before. So anyway, similar to the takings clause, I think it's important to kind of keep things in perspective. Surplus does not equal bad, right?
Right.
What's bad is how you handle the surplus. It depends, could potentially bad. It's how you handle it. In Hennepin County's case, they handled it poorly. And I guess, obviously that's from trickle down from the state law, but be that as it may, that's what happened.
Yeah. Okay. And I'm sure we could talk about what exactly happened to Tyler Hennepin, and maybe we'll do that in another episode. But the reality is there was certainly an aspect of this decision that made you and the committee in Louisiana go, okay, well, we're already revising our statutes. Is there anything else that we need to make sure that we're adhering to, so that we adhere to what Tyler Hennepin said, right? So what was the main thing that you guys looked at, or tweaked in the statutes that you were proposing in Louisiana? I'm sorry, is it a statute change? You mentioned this was a constitutional.
Both.
Is it?
It would have to be both. Yeah. Yeah. It was
both. Okay.
Yeah.
So yes, I guess what were the key components of the Tyler Hennepin that you guys looked at and said, well, we need to make sure that we adhere to that, or we need to make further changes to make sure we adhere to that?
The biggest thing is what we were kind of leading into before a minute ago, which is our current system of partial ownership. Once we try to liquidate that interest, like we give the tax lien investor this procedure to go and get the quiet title to 100% or partial interest, but then go and liquidate that has a dollar value to it. And is that greater or less than the total debt that was owed by tax debtor? Right. It's the proportion of one to the other that creates this disconnect between, potentially problematic, depending upon how you handle that surplus. And what we had to stop and look at was whether our existing system or the proposed new system was just asking for trouble by putting us into a situation where the tax lien investor has exclusive rights to, unless they walk away from it, to go and convert that interest into the equity that might exist, without chance for reconciling it relative to the debt. And I think by contrast, and this is that we actually looked at this and are looking at it, the Florida system really prevents that from happening, because the Florida system is a pure lien. And then at the end of the time period that for the lien to be paid off, there's no automatic right. You can't just like push a button and walk with that lien. The lien holder can't just go forward, right, and say, "Hi, it's my turn." Like I can go convert this now. You have to go now foreclose, like a mortgage company would foreclose on a mortgage, right, and put it in and have another system that assesses how much that lien is worth and says who wants to come, bid on this property in exchange for what this debt is, but you're going to pay something close to an appraised value or some portion of it. At least there's a process for assessing that. And when you do that, when you have an assessed value, but you have the underlying debt, and you could reconcile the difference, you can really put your hand on the surplus and say, I can carve this out and put it on reserve here for the homeowner to have a chance to come back and get it, if it truly is equity and they're entitled to it. So Louisiana do the same thing. We'll say, like, if we stay down the current path of the proposal to go to a bid up ownership, we're saying is that the current lien holder is just going to cruise forward and get whatever they can get, and that's just asking for trouble, right? We're like the same kind of thing that we're talking about. There's no procedure that would assess the difference, the sum of the assessed value from the sale the partition of the property and the underlying debt that created this whole thing in the first place.
Mm-hmm.
And without that in place, we were going to be asking for trouble. But likewise, our existing system is, at first, even myself included, we're thinking like, okay, well, what better system could you have than in light of Tyler, than one that said in its constitution that you should sell the least quantity of property to satisfy the underlying debt. It's actually written in the Constitution. I was like, well, that sounds like the Supreme Court just wrote that. And if you think about it, it sounds fair, unless it's a valuable property, right? And then 1% of a large amount is whatever that equals. And if that's greater than the tax debt, you have a surplus again, right? So, and again, not to say that surpluses are de facto bad, but when you have a surplus and you have a system where the tax lien holder has exclusive rights to just press a button and walk forward and get it, then that's the combination of things that are volatile. So we feel like at this point, and again, nothing's final yet, but we feel like the path forward is, in light of Tyler, we need to have a system that probably like Florida, that has a dual auction system that can have a pure lien and then have a subsequent foreclosure of that lien that recognizes and allows you to reconcile that surplus, and if appropriate, carve it out and put it constitutionally on the side, available for the homeowner to have a chance to go back and get it.
Got it. So basically, it was the method that Louisiana was headed down, or the committee was going to recommended to go down, was the bid up a premium at the lien auction, right? But then at the end of that redemption period, right, there's still an automatic conversion of that lien, right, through a process, into a deed for the lien holder at the time. And basically, what the committee does is go back and say, wait, that wouldn't adhere to Tyler Hennepin. We need to change this. And at the end of that redemption period, now there's going to be a secondary deed auction that would now adhere, in your opinion, closer to what Tyler Hennepin, is saying, right? And then essentially being closer to Florida with, you said, a dual auction, right? A lien auction that will always culminate in a deed auction down the road. It's not exactly the same bidding method. It's still a bid up premium at that lien auction stage, though, correct? Do I understand that?
That's right.
Okay. Got it. And then, like you said, that would automatically, and I think it's important to mention, right? There's a lot of talk of like, well, how do you get to assess value? Well, yeah, this is my opinion. I think the market would agree to this. An assessed value is still an opinion of value, right? The only real test of the value of a property is when you put it up for sale and you see what somebody else is willing to buy for it. That is what a real market value or real value of a property is. And this process would ensure that happens, right? People would have the right to come to that auction and bid it to what they feel that property's worth, and that is establishing what the value of that property is. If that exceeds what the amount of the taxes due are, and fees and et cetera, obviously there's that surplus amount, and then how that surplus amount gets distributed, right? At least the previous owner would have the right to come claim a portion of that. Probably previous lien holders would have the right to come claim a portion of that. And so you believe, and the committee believes, that adheres to the spirit of what Tyler Hennepin is trying to say.
Correct. And keep in mind too that these Supreme Court cases, like any jurisprudence, but particularly at the U.S. Supreme Court level, you're not just trying to think about what words came out of that document. You're trying to think of how's this going to be interpreted by all the other courts underneath it that will be actually ruling on the different fact scenarios and relying on that Supreme Court decision with which to do it. And because keep in mind, there have been like 4 pinnacle cases of the U.S. Supreme Court affecting tax sales, like ever. From the 50s to 4, there've been like major ones, right? And so it doesn't come out very often. And then for the next 20 years, everyone says, think about how often you said Mennonite when you first got into the business, right? Like the Mennonite case, the Mennonite notices, all that kind of stuff. It's like, you don't hear that too much anymore, although it's just become part of like the process of providing adequate notice to interested parties before taking their interest away. But So you have to think beyond just the four corners of the U.S. Supreme Court decision and think like, okay, how are the appellate courts going to be deciding this? How are the state courts going to be interpreting this? And not think narrow-mindedly, saying, well, it complies with the specifics of the Supreme Court didn't really say that, but because they said what they said, this is a logical flow from that. Very, very, reasonable that this would affect this scenario over here. So you kind of you really have to think ahead in how this is going to be interpreted by the lower courts, because that's going to affect the day-to-day cases and the business and commerce moving forward for the next 20 years, not the Hennepin case or Tyler case. And so, not to overthink it, but I think this is, we had a unique opportunity in Louisiana because we were already formed this committee that we're sitting here when the ruling came down, that we're sitting around a table looking at our books and saying, okay, well, this just came across the wire, like let's take advantage of this formed organization and make sure that we're doing this correctly. So we don't have to come back and revisit this in a couple of years once the Louisiana Supreme Court starts interpreting Tyler and saying, you know what, sorry guys, I know y'all spent a decade working on this new law, but it's now constitutional. Let's get it right now, and something that can honor the spirit of what we were trying to do before, which still has a lot of great changes to it, and streamlining the process, shortening the whole period of time where a lien can get into the system, get out. We still create merchantable titles in the back end, and do so constitutionally. And that would be that's the goal of the committee.
Got it. Now, and again, I'm not an attorney, but I would, in all the discussions I've had, with various parties on what Tyler Hennepin means, what they believe the intent of Tyler Hennepin is. I certainly agree that the direction that you and the committee in Louisiana are headed, would satisfy that 100%. Now, obviously, at the end of the day, these are still proposed changes, right? These still have to go through the legislative process and hopefully get adopted. And who knows what other potential tweaks might come along the way. So I'm sure we'll be talking about this again. But what's the timeline as far as when will this be at least looked at and eventually voted on and hopefully put into law in Louisiana? What's that timeline look like?
We're still on target for having this a 2024 law. So the Law Institute that we're talking about, this legislatively formed study, this academic committee, has a lot of weight with the legislature because of the intelligence that's in the room and being able to pour all these resources into creating these proposals. And the legislators get together for a few months and have 20,000 other things to do. So that, they usually rubber stamp, we'll hold hearings, et cetera, but that process, and that would be in the springtime of 24. Of course, assuming the new governor, would ratify it and sign it to law. It then would have the companion constitutional piece, which has to go to public referendum, of course, and get approved by the voters. So it's not very controversial. We're trying to stay away from making, ridiculous changes that might prompt lobbying groups to come in and say like, no, don't vote for that. But you have a lot of no votes sometimes just because it's the word no. So people don't even look at what they're saying no to. But that's every constitutional amendment ever. But anyway, point is it's got to pass all that, and that puts us into if there's there'll be a delayed effective date pending the constitutional adoption or approval of the will of the people of Louisiana. It would be most likely a 2025 January 1st, 2025 effective date. If maybe an earlier, like if there's an earlier election that I'm not aware of next year, it could be potentially earlier than that. But that's the timeline we're looking at right now. Okay.
Well, I'm sure we'll track it. I'm sure we'll talk about it again. Hopefully all of that, takes place and it gets put in place and Louisiana can, say, hey, we're now 100% compliant with Tyler Hennepin. I'm sure the changes, even without that tweak to make it, compliant, we're certainly going to allure more investors because of the structure being a little more friendly, a little more easy to understand, a little more, I'll say, somewhat standard to what other states do. So we'll track that. I'm sure we'll talk again. But Stephen, I greatly appreciate your opinion, your time. You always provide the information, what's going on in a nice, easy to understand way. So thank you very much, and I'm sure everyone listening thanks you, and look forward to talking again.
Yeah, and we'll have more content about Louisiana coming out. And we're gonna actually, our jurisdeed.com is our website, and we're actually launching our blog page coming soon before the end of the year. And we'll hopefully have a lot more content on a regular basis about the effects of this decisions like this in the marketplace, as well as technology, which is where Jurisdeed's focuses on bringing change to the tax sale market, particularly in the legal and title realms. So artificial intelligence and legal tech is a very exciting field to be in right now. So we'll have to have more conversations about that one too.
Yeah, I guess we'll for the folks watching, right, they'll see the link here. But can you spell Jurisdeed again, just so the listeners?
Yeah, think about legal title, right? Jurisdeed, Jurisdeed. So when you're trying to get the maximum amount of your of returns on your tax lien properties, you got to have legal title, you got to have insurable title. You just haven't had technology to help you get there before, not until now.
So check it out, Jurisdeed. So jurisdeed.com.
Right.
There'll be a blog there if you want to learn more about this topic, more about the legal services and title services that Jurisdeed provides. Check it out. Anyway, again, thank you very much, Stephen.
Yeah, thanks for having me.